AC. So we'll May it please your Lordship. Lordship, I am praying for your Lordship's permission to move a unlisted motion matter today, Lordship.
Why? What is the subject matter?
Lordship, my plant of the petitioner company, Lordship, would be closed down today because of a direction of the State Pollution Control Board to the DC on the basis of a closure notice which had been withdrawn in the year 2023 itself, Lordship. The closure notice was revoked and now they have come up with a direction to the DC on the basis of that withdrawn letter that closed down the plan. Lordship, may kindly take it up at 2, Lordship, today. The filing process is going on. Answer obliged, Lordship.
So, filing process is going on.
Going on, Lordship.
As and when it's ready,
Lordship.
take it up.
May it please your Lordship. Lordship, I beg to mention item number 3. Conducting counsel Mr. S.N. is on sanctioned leave, my lord.
What item number 3? Order.
Item number 3. Similar prayer for item number 4 as well, my lord.
Let the matter be called up. No adjournment in motion, admission hearing matter and orders matter. Except for hearing matter, you can,
These are connected matters, my lord.
whatever, let it come up and you can make your mention then, so I can hear the other parties also.
Lordship.
Daily list item number 1.
May I please, your Lordship? Lordship, this is bail in connection with NDPS case. This is the third bail application, your Lordship. 2 bail application previous I filed, but it was withdrawn.
Why?
First bail was withdrawn, your Lordship. I filed before the learned session special judge in Nongpo. But it was not registered and I was entitled for default bail, but it was not registered. So being aggrieved, I came here. But later it transpired that I had no proof that I had submitted. So I withdrawn. Your Lordship was permitted me to file a fresh bail application. And second bail application, your Lordship, I filed joint bail application for 2 accused. So your Lordship directed that a separate bail application has to be filed. So I filed a separate bail application for 2 accused persons. So that's why this is the third bail application before this. Lordship, this bail application number 13, it is for accused Sujit Kumar. Lordship, in this case, your Lordship, on 24/5/2023, this accused person was arrested from Bhoiremong, Ribhoi district. Your Lordship, the other bail application which is for accused Vicky Kumar, your Lordship, during that period of time, Vicky Kumar, he was driving a local taxi. Two person, your Lordship, they hired my this vehicle, local taxi, to drop them to Bhoiremong. So on the way, your Lordship, the custom officer, they intercepted the vehicle, and since it was night, I requested my brother, Vicky Kumar requested his brother Sujit Kumar to accompany him because it was already night time, so he was afraid. So he said that let us go together. So Sujit Kumar agreed to accompany his brother Vicky Kumar, who was driving local taxi. Then, your Lordship, 2 persons, passengers were there in the local taxi. Both all the 4 accused persons were intercepted at Bhoiremong. Alleging that, your Lordship, that they have found some contraband lying in the forest somewhere in Layarbang in Ribhoi, and they said that this contraband belongs to us. So, your Lordship, those 2 persons who hired the vehicle, they were from Tripura. Believing that they were bona fide passenger, we agreed to take the vehicle. Your Lordship, from the vehicle nothing was recovered. Nothing was recovered from their possession also, and it was alleged that they have and from both the passengers also nothing was recovered. Only allegation was that they found some contraband from the forest area, and accordingly, your Lordship, they intercepted and then they detained us and then they brought to the custom office, and they said that this contraband belongs to the accused person. Your Lordship, investigation was carried out. 6 months they took time to carry out the investigation, In the investigation, nothing is found, and final complaint has been filed. Nothing found. Based on mere statement of the accused, that one of the accused from Tripura, he said that it belongs to me, and it was somebody has given to him. But there is, of course, there is nothing is that, even though that it belongs to him, that he has kept that passenger, and from my position, nothing is recovered. So in the complaint, your lordship, nothing is there that it is me who has kept the contraband and it belongs to me. They said that in the complaint, it is said that I was in communication with one person whose CDR is not available here in the record, and they said that since I was communicating with them, so that's why I am also involved. But from that particular person also, nothing was that contraband was not recovered. It was, of course, recovered from forest area. No photograph taken on the spot. There is no document that it was prepared. Document was prepared that for lifting. Photograph not taken in the final complaint. Nothing is there. So, your lordship, in this particular case, your lordship, I deserve that bail, your lordship, because there is nothing in the final complaint. Only because it is commercial quantity, your lordship, they cannot say that anybody can detain, and they said that it belongs to you. So if if anything they can produce, your lordship, that how I am involved, no, nothing is there.
So you mean to say that there is no link?
Yes.
As far as your nexus with the
Even though, your lordship, nexus, yes, but from whose position, who has kept, that is not there also. In the record, there is nothing is there that who has kept those contraband. On mere statement 67 of the other accused, not my accused, they said that it belongs to some person from Tripura. So that also, your lordship, 67 as to, it is not in view of Tufan Singh versus Tamil Nadu. That, your lordship, is but as I'm not going on all those technicalities, your lordship. My submission is that, your lordship, that nothing was recovered from my position. Local taxi, your lordship, public vehicle, I have to take the passengers. And moreover, Sujit Kumar, he just merely accompanied because it was night time. So on this ground, your lordship, I am paying for bail.
So charge sheet have been filed?
Yes, your lordship. Final complaint was filed.
But today is just moving it because the matter is from Nongpo ballot. So lordship gives me 2 days time. I'll get a copy of charge sheet and try to point out what are the charges against this accused person. The matter is taken up to maybe Thursday or something.
You see, I've gone through the petition. What Mr. Pandit said is also, you have to find out the CDR details. And what is the, probably you could only get that link if at all.
So that's what I thought. I'll go through the charge sheet. The charge sheet is already submitted. I can just place all that.
Today is
Monday, Thursday.
Take it up on Wednesday then.
Thursday. Thursday will be second.
What Mr. S. Pandit, the counsel for the petitioner. Dr. N. Musica, DSGI, has submitted that he may be allowed to produce the CD as well as the charge sheet or relevant materials to be able to stay out the case of the respondent. As prayed for, so I also pray aloud. As agreed to by the parties, list this matter on second.
Item number 2 also
Same order.
Item number 3.
Yes. So you say?
My lord, conducting counsel Mr. SN is the conducting counsel for this matter. He's on sanctioned leave, my lord. I'm humbly praying that after this may be taken up after 2 weeks.
No objection.
Mr. Counsel, appearing for the petitioner has submitted that the Learned Conducting Counsel for the petitioner, Mr. SN, is on sanction leave and could not appear before this court today. It is therefore prayed that this matter may be adjourned for the day. The prayer not be objected to by the respondent. The same is allowed. As prayed for, this is matter after 2 weeks.
Similar prayer for item number 4, Your Honor. These are connected matters.
4.
4 also.
Same order.
Highly obliged.
Highly obliged.
Item number 5.
Yes. You're for? 2. And what else is required? Yes, miss.
Your Lordship, let file first the affidavit and we'll go through first, and if necessary, we'll file the rejoinder.
State has filed the counter.
Lordship, yes. Yeah, fine.
And we have reply also for the.
You have filed your rejoinder.
Yes. For the state reply.
Mr. Learned Counsel, appearing for the petitioner, has submitted that the rejoinder affidavit to the counter affidavit filed by the state respondent 1 has been filed before this court. Mr. Learned Counsel for the respondent number 2 has in the meantime wait for some more time to file the counter affidavit as far as the respondent 2 is concerned. The prayer is allowed. Let the counter affidavit be filed within the next date fix. This is matter after 2 weeks.
Obliged.
Item number 6.
May it please your lordship.
Yes. Yes, what is
My
required?
lord, item 7, my lord.
Yes.
The writ petitioner has filed the instant writ petition, my lord, seeking compensation for land which has been for his claim is that his land has been acquired, therefore he is entitled to compensation.
Is that so?
No.
My lord, in short, on the last occasion, my friend has already argued. Here's an issue with regard to my shifting of the transmission, my lord.
Mr. Kumar, what are you?
So he's appearing for the response.
What is his case, my lord? I will place that case, my lord. If if your lordship kindly see synopsis of his case, synopsis of amended writ petition.
Yes.
And if your lordship will see the first, kindly see paragraph synopsis, my lord.
Yes, yes.
Synopsis says that brief facts of the cases petition is agreed by the legal action of respondent 4 and 5.
Yes.
4 and 5 in forcibly occupying and encroaching over petitioner's land at the industrial estate area, Clitracy, West Jantia Hill, Meghalaya, on erroneous presumption that respondent 4 and 5 is the owner of the land. Respondent 4 and 5 have taken inconsistent stand regard to ownership of land in industrial estate area, inasmuch as said land is not acquired for the said purpose. At the same time, it has been issuing the orders petitioner to stop constructing legal position so far as land in question is concerned, therefore taking away land of petitioner by 4 and illegal, encroaching the violating fundamental right, and the petitioner is the owner of the land, my lord, next paragraph, of industrial estate, and who is sought to forcibly acquired by the respondent 4 and 5 in gross violation of fundamental right. So the case which has been set up before your lordship by the writ petitioner is that land of the petitioner has been acquired by 4 and 5 without following the principle, my lord, and it amounts to violation of principle of
Yes.
arbitrariness, Article 14, fundamental right, my lord. That is his case, my lord.
Yes. But you have
So
not,
for that purpose, my lord, writ has been filed.
but you have not
Kindly
advanced
see
argu-
the
you have
argument in the main
not,
writ
just,
also.
Yes, Your Lordship.
you have not advanced argument as far as the acquisition is concerned.
I mean, the land. It is already the lease agreement is there. Lease agreement is between the.
You are alleging that your land has been acquired. But in your argument, you have not said anything about the land being acquired or so. What you have, concentrated on is only with regard to the high tension wire.
Because the high tension line was coming over my things, unit, Your Lordship. For that, my entire functioning is, because that is surmounting to requirement only. Because my entire unit is stopped. No workers staying there. No activities going on, Your Lordship.
See, but these are two different aspects. As far as acquisition of land is concerned, it would be a different, department altogether.
Your Lordship.
But as far as the
High tension.
setting up of the high tension or running over of the high tension allegedly over your land, that is the part of the MECL. So,
Yeah, in fact, Your Lordship, we are not blaming the state also. Because our main case is against the 4 and 5. Exactly. So our entire demand, everything, okay. Because the moving that power line, it lies with the state government. Because they have to move it. But the compensation, as for the compensation, we are not claiming from the government. Because we know we're the leaseholders, we're the leaseholder. But where is my right? I'm paying all my duties and everything.
that is what.
Now,
As
my
far
lord,
as,
kindly see.
as far as your status as a leaseholder, that nothing has changed.
No, nothing has changed. This is on
Yes,
record.
still
It is on record.
That has also changed, my lord. His right as leaseholder has also changed, my lord. I will so, because my friend has not placed the lease
I'll
agreement.
come to that.
Okay.
He has not placed the lease agreement also, my lord. He should have, because he is claiming that he is a leaseholder. He is having lease of the land, my lord, by virtue of lease document, my lord.
Okay.
It is his duty to please place the lease document which he has not placed, and he has suppressed that document, my lord.
Okay.
Because this practice should not be accepted, my lord, because it is if petitioner is setting up a case before your lordship, it is his duty to place the lease document and say on the basis of lease document, I am entitled to some compensation, if at all in accordance with law, my lord. But unfortunately, my friend has not even placed that lease document, my lord, but it has come in the counter affidavit. But it is his duty in my humble submission, to place the lease document. Your Lordship, kindly see prayer, my Lord. Now kindly see prayer. Because I have to proceed as per his case set up in the writ petition. What he has argued, I don't know whether that case is made out in law or not.
Yes.
If your Lordship will kindly see the prayer, prayer says, my Lord,
yes,
it most respectfully pray that your Lordship would be graciously pleased to admit this petition, issue rule calling upon the respondent to so call as to why a writ in the nature of mandamus certiorari should not be issued, directing the state respondent to shift the ST line at the land of petitioner industrial estate pass pass a direction to respondent 4 and 5 to revert the possession of land illegally occupied in industrial area to the petitioner forthwith, and pass further mandamus directing to 4 and 5, my lord. Kindly see the memo. So the prayer in essence is, my lord, direction to the respondent number 4 and 5 to shift the line, shift the ST line, my lord.
yes,
And 4 and 5, your lordship has seen in memo parties, it is the elected MECL and MECL, which is 4 and 5, my lord. Kindly see the memo parties. 4 is executive engineer.
yes,
So direction is to 4 and 5 to shift the ST line, my lord.
yes,
Your lordship has been made aware of the fact that this is the land owned by respondent commercial, district commerce and industry department, industries, my lord. This is owned by the government.
This is the
And
this is an industrial estate, isn't it?
Industrial estate, my lord. And this land is owned by the government, not by the petitioner. And petitioner is mere leaseholder in, and that lease has also been cancelled, my lord. That as on today, the status is that he is occupying the leased land illegally also, my lord. That I will show from the document also. So there are two issues which fall for your lordship's kind consideration. One, whether writ petitioner is entitled to relief prayed by him, that is direction to respondent number 4 and 5 to shift the ST line. Second, my lord, whether because the right to shift the ST line or the decision to shift ST line rests with the state government, that is Director Commerce and Industries, my lord. If land has been leased to the petitioner by Director Commerce and Industries and it is not per se usable, then leaseholder will have a claim against the Director Commerce and Industry, saying that the land which has been leased to me is or cannot be put to use, and therefore I am suffering loss, my lord. That plea has to be there against the Director Commerce and Industry. The second plea which my friend's client could have taken, my lord, is this, that the land has been leased to me. I have paid so much consideration. I am paying rent per month and I have not been able to use the land. Therefore, I have suffered the damages, and therefore you pay the compensation for not allowing me to use my land. These are the two separate set of facts, or the set of the case could have been set up in civil suit, in my humble submission, not also in the writ petition, my lord. But be as it may, since my friend has set up a case before your lordship, I prayed, my lord, that direction be issued to respondent number 4 and 5 to shift the ST line, my lord.
Yes.
The prayer, your lordship, first kindly see the lease document, my lord, which is there. Kindly see the lease document, which is at page 8. It is part of the counter affidavit of respondent number 2 and 3, my lord, at page 6, my lord. Page 6 of the counter affidavit of respondent number 2 and 3, my lord.
This is affidavit dated.
And kindly note the date also, my lord.
Just one. Page.
Page 6.
Lease deed.
Yes, my lord. Lease deed, my lord. Kindly note the date of the lease deed. It is 7th September 2012. 17th September 2012, my lord.
Yes.
And kindly see the clause, my lord.
Yes.
Paragraph clause 5, my lord.
Yes.
That the lessee shall, within 1 month from the date hereof, submit to the lessor or his authorized agent
Yes, please continue.
Authorized agent for his approval the specification, plans and other details of every said or structure to be constructed on the demised premises, and at the direction of lessor or his authorized agent, lessee shall amend his own cost the said plans, specification and other details.
Yes.
So requirement is, my lord, that he will submit to the lessor or authorized for approval of plan, other details of every said. The case of the Commerce and Industry Department is, my lord, that no such plan has been submitted within a period of 1 month. And there is no material to show that it has been placed. The petitioner has not made any averment that he has placed. Now the consequences are provided in 7, my lord. Kindly see clause 7, 8. Kindly see page 8, clause 7 and 8.
Yes.
Even that lessee shall not erect or build, clause 7 at page 8, my lord. Lessee shall not erect or build or permit to be erected or built on the demised premises any building, shed or other construction other than those approved by lessor or his authorized agent, nor make any subsequent addition or alteration to the existing building and shed at any time except with the written approval of lessor or his authorized agent. I have seen, my lord, that the requirement in clause 5 is to submit the plan. The requirement of 7 is that he can construct or erect only with the permission of the lessor, my lord. And 8, my lord, clause 8 is, in the event of lessee fails to comply with the terms and conditions hereto set forth, lease shall be automatically terminated with the right of lessor or his authorized agent for re-entry. So there is a clause in the lease agreement that if you do not comply, lessee does not comply, then there will be automatic termination of the lease agreement. The case of the department is that he is not complied with this provision, my lord. So as on today, in my humble submission, in the light of clause 8, lease has stood terminated because he has not complied with the requirement, my lord, and that letter is also on record, my lord, by the industry department. He has not complied with this requirement, my lord. Kindly see paragraph 4 of the counter affidavit, my lord.
Yes.
4 and 5. These two paragraphs are relevant for the purpose of adjudication of this matter, my lord.
Yes, please read out.
Yeah, with regard to statement made in paragraph 2, 3 and 4 of the writ petition,
yes,
the humble answering respondent would state that 33 kV line which passed through the carrier is the land owned and possessed by Department of Commerce and Industry. So the land admittedly is not owned by the second paragraph, my lord. With regard to statement made in paragraph 5 of the writ petition, The humble answering respondent begs to state that petitioner, who is proprietor of Bilsina War Pasa Sawmill veneer, had been given on lease plot of land measuring 3,000 square meter in Kletrisi Industrial Estate, Kletrisi, West Jantia Hill, for setting up saw cum veneer mill for a period of wide lease agreement dated 17/9/2012. Copy of which annexed. As per clause 5 of the lease agreement, it is required that lessee shall, within 1 month from the date hereof, to submit the lessor or his authorized agent for his approval, the specification, plan, and other details of every shed or structure to be constructed on leased premises at the direction of lessee or his authorized agent. Lessee shall amend at his own cost said plans, specification, and other details. Further, the undergoing construction of RCC building in the leased property undertaken by the petitioner, which the ST line passes, the petitioner has not submitted any proposal to answer respondent for construction of structure in contravention of the clause 5 of the lease agreement. So there is a clear, unequivocal, categorical statement that in terms of clause 5 of the lease agreement, my lord, no plan has been submitted. And your lordship has seen the consequences. Your lordship has seen the consequences. Consequences is that lease shall stand terminated automatically, my lord. There is no challenge to those provisions before your lordship. The petitioner has not sought to challenge those provisions, my lord. Therefore, as on today, in my humble submission, legal position or factual position is that the petitioner has no right, title, interest in the said land, because admittedly no such proposal, nothing has been submitted to the Industry and Commerce Department, my lord. So that is my first limb of the submission, my lord, right of the petitioner to claim compensation with respect to a piece of land which is not owned by him, and as on today, in terms of clause 8, he is not even leasing. Second submission, my lord, is that your lordship has noted the date of lease agreement, my lord. That is of 12, my lord, 17 September 2012, my lord. That your lordship has already taken note of. Now, 17 September 2012, my lord, and now kindly see the counter affidavit of MECL, my lord.
Yes.
The first annexure, my lord, of the counter affidavit, which is at page 7. Is the letter of...
Just
I'm sorry. The counter affidavit of respondent number 4 and 5.
4 and 5. This is dated 13/12.
This is 22nd May 2007, my lord. Page 7.
This one.
December, my lord. The affidavit was filed in December 2018, madam.
13 December 2018, it has been filed, my lord.
Yes, yes.
Paragraph page 7, my lord.
Page 7.
Yes, my lord. Of the counter affidavit, annexure 1, my lord.
Yes.
Lordship having the copies, my lord. Yes, Lordship 22nd May 2007.
Yes.
The letter is addressed by Meghalaya, erstwhile Meghalaya State Electricity Board, to the manager DIC Kletrisi, my lord, and the subject is construction of 33 kV line from Kletrisi village to Nartiang village. Sir, with reference to the subject cited above, I am pleased to inform you that Meghalaya State Electricity Board will soon start the construction of 33 kV line from Kletrisi to Nartiang village. The aim of this project is to improve and maintain a stable power supply to your area. In this connection, the board needs your full support and cooperation so that construction work, once taken up, be not interrupted or disturbed for the smooth and timely completion of the project. Your sincere support and cooperation would undoubtedly help us to speed up the construction work for interest of the board in particular and people of the area in general. So 2007, my lord, request was made to the manager DIC, my lord. Lease is of 2012, my lord. Be as it may, my lord. My friend is relying on the letter at page 8, my lord. My friend, page 8 of this counter affidavit in the writ petition, my lord.
Yes.
Page 8 is a letter by Director of Commerce and Industry to the MECL, MPDCL, my lord, MPDCL, and this is 6 October 2016 letter. Sir, with referring to your letter above, I am to reiterate that 33 kV line and 11 kV line, which passes through the 3C industrial estate in general and industrial unit in particular, were constructed without obtaining prior permission from the department. As such, it is incumbent upon corporation to shift the line at its own cost. Question of payment by this department or the unit does not arise at all. So this is the letter on which my friend has placed reliance, my lord. Now kindly see, this letter has been cancelled by the Commerce Department, my lord. Which is there at page, my lord. Kindly, I'm sorry for troubling your lordship. Kindly come back to the counter affidavit of the Commerce Department, my lord, Annexer 2 at page 12, my lord. The counter affidavit of respondent number 2 and 3, my lord, and at page 12.
Just a moment. Page 12.
Page 12, my lord. 8 July 2019, this is a letter by Director of Commerce and Industries.
Yes.
On re-examination of earlier communication, issued white letter number so and so dated 29/11/2017, my lord. That letter I have read out just now, my lord.
Yes.
And taking into account that the then MESEB, now Meghalaya Power Distribution Corporation, has sought cooperation of all concerned authorities, including this department, prior to construction of so and so line passing through Plate 3C Industrial Estate, and the construction of is meant for interrupted supply of power and for larger interest of public, later dated 29/11 is hereby recalled and cancelled.
Yes.
So the letter by which 2017 letter which my friend is relying, my lord, has been cancelled by Commerce and Industry Department, my lord. So now his prayer, my lord, is what? Compensation for passing of ST line on alleged lease, purported lease in his favor, my lord, or direction to 4 and 5 to shift the transmission line, my lord. The Commerce and Industry Department says that it is in public interest and it will help in maintaining power supply, which your lordship had seen at page 12, my lord. It is for larger interest of public and uninterrupted power supply, my lord. Now the question which falls for your lordship considered in law. Factually, I have shown two parts, my lord. First part is, my lord, that this person or the petitioner before your lordship is not having any permission from the Commerce and Industry Department for constructing this said, my lord. That document is also on record, my lord, which I can, that document is also there, which shows that there is no permission granted to the person in constructing the said, etc., my lord. Now, so first part is that there is no permission, my lord. Second part is, my lord, that he has no legal right whatsoever, because writ petition is maintainable only when the legal right of a person has been infringed by any action of the state authority, my lord. Third part is, my lord, he is seeking in writ petition somewhere there is a reference in the pleading that compensation, he is entitled to compensation. Land has been acquired and his valuable property right, if I take it under Article 300, capital A, has been taken away. But his right to hold property as on today is not itself clear, my lord. It is nebulous. Whether this honorable court, I put this question to myself, my lord, in such a disputed question of fact, issue direction to the state authorities to pay compensation and do something which is not in accordance with law, which is not in consonance with the case of petitioner, my lord. In my humble submission, petitioner has failed to make out any case. Now coming back to my lord, the shifting of ST line, my lord. Now kindly in this regard, my lord, I am again taking back and forth to your lordship. Kindly see the writ petition and the annexer. Annexer is, my lord, annexer and page 15, my lord. Annexer is A2. Annexer is A2.
Yes.
A2, my lord.
Yes.
Sri Vansuk Pasa, Industrial Estate Area, area so and so. Submission of bill for shifting or reconstruction of 33 kV line passing through your compound at Industrial Estate so and so. With reference to the subject cited above, please find herewith a bill number so and so amounting to 1,51,334, only being the cost for shifting and reconstruction of so and so, passing through compound of 3 Pasa Industry. This is for your information, and this is the bill which was submitted, my lord. Bill detail is there.
Yes.
Now the dispute was being raised whether, my lord, initially in 2016 by Commerce and Industry Department at page 18, which I have to fairly place before your lordship. Page 18, my lord.
18 of the petition.
Page 18 of the writ petition, my lord.
Yes.
Dispute was being raised by Director of Commerce and Industries, my lord, stating that
yes.
This letter important 6 October 2000. With reference to your letter cited above, I am to reiterate that 33 kV line, a line which passes through the Clitrici industrial estate in general and industrial unit were constructed without obtaining permission. As such, it is incumbent upon the corporation to shift the line at its own cost. Question of payment of department or unit does not arise. So, Commerce and Industry Department questioned the claim of the claim of the MPD share to seek 1,33,000 for shifting of the power line. And this, my lord, your lordship has already noted that it has been cancelled. The Commerce and Industry Department, in larger public interest, has cancelled the entire process, my lord, which 2019, which I have already read out, my lord. My friend is relying on that letter, my lord, to say that say that he is entitled to compensation, etc., my lord. Now, kindly see in the light of the legal position, my lord. Legal position is reflected in the counter affidavit of MECL with regard to shifting of ST line, my lord. And that position you will also will find at page, because relevant part of the is already placed in the record, my lord, regulation, my lord, dealing with this. Kindly see the counter affidavit of 4 and 5, my lord.
Yes. Yes.
Kindly see paragraph 6 first, my lord, of the counter affidavit.
So,
paragraph 6 at page 2, my lord, of the counter affidavit of corresponding number 4 and 5.
yes.
With regard to the statements
Yes.
made in paragraph 4 and 5 of the writ petition, the deponent denies the same. Deponent states the transmission line of the department had been constructed way back in year 2007. After informing all concerned authority by letter dated 22/5/2007, including the office of respondent number 2. The letter of 2007, my lord, I have read out. Paragraph 6.
Yes.
22/5/2007. There was no objection raised at that point of time for construction and erection of ST line through the property of respondent number 2 and unit occupied by petitioner which falls under the industrial unit of respondent. However, on 11th March 2016, After lapse of almost 10 years of the construction and erection of ST line, the petitioner, while dated 11th March 2016, requested the Office of Respondent 4 to shift the existing line, which is passing to property of petitioner ever since intent to construct a building. The electricity transmission lines are basic and essential public utility service and have been laid down by following all prescribed rules, regulations and guidelines under the Electricity Supply Act 1948 and the Electricity Act 2003. As far as request for shifting alteration of any existing transmission line is concerned, Regulation 63 sub clause 1 of Central Electricity Authority, measures related to safety in electricity supply regulation 2010, provides that in case a landowner seeks alteration, shifting of any overhead line, such person is liable to pay the cost of alteration. Thus, mechanism is provided under the statute and the rules for redressal of such issues. Respondent 4 is on receipt of application has prepared an estimated bill for shifting of line and by later dated 22/4/2016 informed the petitioner about the cost of shifting at the line along with estimated bills as provided in 63(1) of the said regulation, which is reproduced here. You Lord, kindly see the regulation itself, which is annexed at page 13, gadget notification.
Yes.
This is the regulation of 2010, which reference I have already given, my lord, in 2000, and it is made under the Electricity Act of 2003, my lord. It is a statutory regulation, it binds the parties, and this Honorable Court will also follow the statutory provisions, my lord, because we have to go by the legal provision, my lord. Kindly see 63. Erection or alteration of building, structure, flood bank and elevation road, if at any time subsequent to the erection of an overhead line, whether covered with insulated material or not, any person proposes to erect a new building or structure or flood bank or raise any road level or to carry out any other type of work, whether permanent or temporary, or make in or upon any building or structure or flood bank or road any permanent or temporary alteration, he and the contractor whom he employs to carry out the erection, addition or alteration shall give intimation in writing of his intention to do so to the supplier or owner of the electrical supplier or owner and the electrical inspector, and shall furnish therewith a scale drawing showing the proposed building, structure, flood bank, road, any addition, alteration and scaffolding thereof required during the construction. 2. My lord, upon receipt of such intimation, the supplier or owner shall examine whether the line under reference was laid in accordance with provisions of these regulations or any other law. 2. Whether it is technically feasible. 3. Whether it meets the requirement of right of way. 4. Whether any such person was liable to pay the cost of alteration of the overhead line, and if so, send a notice without undue delay to such person together with estimate of cost of expenditure likely to be incurred to so alter the overhead line and require him to deposit within 30 days of receipt of notice with the supplier owner the amount of estimated cost. 3. If such person dispute the cost of alteration of overhead line estimated by the supplier owner or even the responsibility to pay such cost, dispute may be referred to electrical inspector whose decision shall be final. Electrical shall estimate the cost of in following way. My lord, so there is a complete statutory mechanism provided under regulation 63. Read with paragraph 6 of my lord, this counter affidavit, my lord.
Yes.
So first, my lord, as on today, your lordship has seen that the petitioner has not established his right over the land which has been purportedly leased to him, my lord. There is no right. Second, petitioner has not placed any material to show that the petitioner has obtained any permission for starting the construction, my lord. Third, your lordship has seen that this overhead line was started in 2007. Lease is of 2012, my lord. Much prior to the lease agreement. even lease agreement says that it was given with effect from 2007, my lord. But the fact is that in 2007, the permission has been granted and there is a complete statutory mechanism through which the parties or the state has to work, my lord. Now at this stage, if the petitioner first he has to establish his right which has been cancelled by, which has not been accepted by the Commerce and Industry Department. I have shown, my lord, 2019 letter, my lord. Kindly see 2019 letter once again, which is at page 12 of the counter affidavit of the respondent number 2 and 3, my lord.
This one you have referred.
Yes, this one is referred, my lord. The light of legal submission, my lord. Kindly see. The earlier 2017 letter has been cancelled by respondent number 2 and 3. So the owner of the land is respondent number 2 and 3. The petitioner is purportedly leaseholder of the area over which the ST line is passing through, my lord. Regulation 63 requires that the cost of shifting should be borne by the owner or the leaseholder, my lord. The statutory mechanism is there if the owner or the leaseholder is not satisfied with the cost provided by the department, my lord, he can there is a mechanism for determination of cost and he can approach the electrical inspector. There are certain preconditions, my lord, also whether the electricity department has right of way or not, my lord. All these issues, my lord, in my humble submission, are facts, disputed question of facts. No firm right, no proper legal right or legal foundation or factual foundation have been laid down in writ petition. Seeking your lordship's intervention under the extraordinary jurisdiction of Article 226, my lord. There is a judgment directly on this point, my lord. Unfortunately, writ judgment
Yes.
has been placed. Judgment
Have you given the list of books?
Only we are having
Only one.
one judgment, my lord. The citation is, my lord, 2012, 12 SCC 170.
Yes. Yes.
Now, my lord, if I take the placitum itself, my lord, maintainability, interim alternate remedy, but not equally likelihood of, my lord, kindly see the paragraph 16 to 24.
Yes. Yes.
Paragraph 16, my lord. A reading of the order of High Court would show that the refusal to interdict the developmental work undertaken or about to be undertaken is on the ground that petitioner has an efficacious. The writ petitioner exercising jurisdiction under article is fully empowered to interdict the state or its from embarking upon course of action to be detrimental to rights of subject. Though in exercise of jurisdiction in the domain of public law, such as restraint order, may not be issued against a private individual. This, of course, is not due to any inherent lack of jurisdiction, but on the basis that public law remedy would not be readily extended to settlement of private dispute between individuals. Even where such an order is sought against a public body, writ may refuse to interfere if it in the process of determination of disputed question of fact, a title would require to be adjudicated. Now, at this point of time, my lord, your lordship will have to, if my petition, if the title would be required to be adjudicated, my lord.
Yes.
What is the title, my lord? Title which is being sought is that I am the owner of the land, Commerce Department and they may be in occupation of the leasehold land, my lord. But that occupation on the face of clause 8, my lord, will not be maintainable, my lord. And in the light of the principle laid down in paragraph 21, my lord, I have placed the material 21 of the judgment, my lord. I have placed the judgment. 21, my lord, of the High Court, in our considered view, ought not to have disposed of the petition at this stage in the manner it has laid down. Instead, ought to have satisfied itself there was actually a serious dispute between the parties on the question of ownership or title. Only in that event, High Court would have justified relegate the petition. So, my lord, what I am trying to submit, my lord, that the scope of your lordship's power under Article 226 is wide enough. But when the matter or materials are placed before your lordship, showing clearly that even title is inchoate, right is inchoate, and no legal right has been infringed. And here in this case, petitioner is seeking direction from your lordship to respondent number 4 and 5 to shift ST line, my lord. For that also there is a process, my lord. There is a process, my lord. And there is a statutory regime, my lord. In the light of all these facts, in my humble submission, writ petition is not maintainable and it is even barred by law. And the title of the petitioner itself in question, even Commerce and Industry Department has resigned its 2017 letter by 2019 letter. That is all I have to submit, my lord, on this.
My lordship.
Yes.
My only limited issues out here is, first of all, I like to correct my learned senior that we are not claiming any compensation from the state. We are claiming compensation from the respondent 4 and 5, who is encroached to my things on my property, which is on the leasehold. And now the question is coming is that my lease is not more existing; it is automatically disputed. I'll bring to the notice of you. Lordship, the rejoinder affidavit of with respect to the respondent 2 and 3. It is filed on 25th September 2019.
Rejoinder affidavit to?
Yes, in respect to the 2 and 3, respondent 2 and 3, rejoinder affidavit.
2 and 3?
2 and 3. It is dated 25th September 2019.
Yes.
Lordship, page 5, annexure A1.
Yes. Just one more. Page?
It's page 5, Your Lordship. Annexure A1. That is a blueprint. But it's not renewable. I file an affidavit, small affidavit of the things. Type copy.
Type copy?
I already filed on type copy. Dated 23rd August 2022.
Just
Affidavit. With respect to this annexure.
Just
An affidavit by the petitioner to bring on record the type copy of the annexure A1.
You're referring to this
Yes.
type copy of
Type
annexure?
copy, yes. The page 3, Your Lordship. That is the type copy of this annexure
Just a moment.
A1.
Page 3.
Page 3, Your Lordship.
Page 3. Page 3 is the verification.
Yes, page 3.
Yeah, this the diagram.
Yes, the diagram, Your Lordship. This is the type copy of the diagram of this blueprint.
Land of DIC Industrial Estate.
Industrial Estate. The land of Bislana Warpasa, Sawmill Convenia, Kletrichi, Industrial Estate, Elaka Juai.
Okay. It's page 4 according to.
Actually, it should be 3. I apologize for that.
No, I think page 3 was overwritten by 4. Whatever. Yes. Please. What is this thing?
This is just in the right side in the below.
Yes.
Shall I read?
Please.
So drawn by the SD Junior Engineer PWD Road, Urban Subdivision Juai. Countersign, Your Lordship. This is very important.
Yes.
On 4/5/2007 by Deputy General Manager Technical Meghalaya Industrial Development Corporation Limited. So that means my lease agreement was executed in 2012, taking the effect from the 25th April 2007. Commencing retrospective effect from 2007, 25th April. And I submitted this blueprint to the department on 4/5/2007. That means not even within 1 month. So, by the argument of the respondent, my senior counsel saying that automatically it has been cancelled. If the case, why I'm still holding that things? I've been never sent the notice to vacate that thing. 2007, if it within mount, if I've not taken a permission, if the construction is on, why so far till date, no notice has been issued to vacate that land? I'm still holding it, I'm doing business. I am paying all the taxes to the government and the charges. My license are renewed. When my license are renewed, so we can presume that this lease is still in existence.
Have you annexed all those papers?
Yes, yes.
They are renewal of license and all those things?
Yes, that I'll complete. This is a renewal. This affidavit. This affidavit is very important.
Lord, these are the additional affidavits which are not part of the writ petition, but be as it may, my Lord, I will answer that also.
These are all rejoinders. So
these are all part of the new case in the rejoinder, my Lord.
No, this
that is for you to object at a relevant point of time.
Yeah, I understand, my Lord.
Worship.
But be as it may, I will answer that also if rejoined.
The affidavit dated 23rd August 2022. Additional affidavit to bring on certain documents to ascertain the inception of the unit.
Just a moment.
23rd August 2022. Additional affidavit.
Yes. Yes.
Yes. Page 11. Annexure B5. This is the license, Your Lordship, which is issued in
Just one.
12.
License
To do that particular business.
dated 20. Is it June?
12 June. 12 June. It is in page 12, Your Lordship.
Yes.
12 June 2006.
Yes.
And page, my Lordship.
So this is required to be renewed.
This is renewal every year. It's still going on. We are paying it.
Where's the latest renewal?
Latest renewal I don't have at present, Your Lordship. At present I don't have, because this is as far the things are concerned, because this is regarding the inception.
Okay, we'll take it that your license have been issued on 12 June.
12 June, thereafter it is continued.
You don't have the latest.
At present, the present one I don't have.
No, but what do you have with you? Till when was it renewed?
No, that is I have to take the things. I have to ask. No, actually, Your Lordship, this is the inception, because this
No, yeah,
affidavit.
inception fine. Fine, inception fine. Because the argument of the respondent is that, okay, let's put it that there is no quarrel that you have not received the license.
Yes, sir.
The only objection against you is that you have not make any construction or given those plans and everything within 1 month, which according to clause 8 of the regulation,
Clause 8 is there.
it's your license is deemed to be
cancelled.
But to counter that, you have to show with the renewal after 2006. That should be on record.
That should be, yes. So I just pray, because this affidavit was filed on the basis of the inception, when it is started. As far as the license concerned, I have to collect that. I need some more time.
And Lord, this license is, Lord, there is one more. I'm sorry to interrupt, Lord. If you Lordship will see, this license is only for sawmill, not for this sawmill, Lord, because this is a forest department license, Lord. And you see, this is nothing to do with the leased land.
Sawmill,
and you see,
license will be issued on the
cannot
basis.
cannot be constructed on the air. It has to be somewhere.
Yes, Lord. No, but I'm having sawmill, my Lord. I will construct the sawmill in some land, my Lord.
Exactly.
But license would say that it is with regard to industrial estate, my Lord. Can you see the license?
First, we have to confine ourselves to the fact that license was issued
For sawmill.
Yeah, for sawmill. Thereafter, it is the onus is on the petitioner or the licensee to erect the sawmill wherever he is allotted to or permitted to.
Yes, my Lord.
Now, you see, the way the facts and circumstances would show that he has erected or constructed the sawmill at the place of the
industrial estate.
Yes. So,
yes, my Lord.
So that I don't think that's disputed.
Only two things are, my Lord, I have to submit, my Lord. Your Lordship is right that he has got the sawmill, license for sawmill. Second, your Lordship is also right when your Lordship says that he may have constructed. My Lord, getting license for sawmill is one, and getting permission to construct it at certain site is second, my Lord. Now, so far as second part is concerned, my Lord, that there is no document placed by petitioner before your Lordship.
Okay.
And third, my Lord, even assuming he has constructed, what he is seeking from your Lordship is, kindly see, I'm sorry, prayer. What he is seeking is compensation under 2013 Act, my Lord. Kindly see prayer. What is his prayer in the writ petition, my Lord?
I think we have gone through that.
Yes,
prayer,
yes,
the prayer is,
yes,
prayer is for compensation by respondent 4 and 5.
Directed 4 and 5 to revert the possession of land illegally occupied in industrial estate to petitioner, and further directing respondent to pay compensation for lost damages caused to petitioner or possibly caused to the petitioner, my Lord. So these are the two prayers, my Lord: damages and direction.
You say that the respondent 4 and 5. This is the MCL.
Yes, electricity department, electricity board.
How is it that you have alleged that they have encroached or taken illegal possession of your land, when what they have done is only to erect the high tension wire which has passed over your land, not No,
I'll answer to
not
that.
on the ground.
No, what is now? If you take the
It
wide
may have affect your activities.
yes. If I take the
that-
wide definition, Your Lordship, the encroachment. Suppose this is my unit, okay, and something has come over the things which is causing a great danger. That is, it is on record, but it is affecting. That means entire my activities is stopped.
Does it come under any definition of the Eastman Act?
So that, and I'll just I like to bring here because learned friend, no, it's my learned seniors mentioned in the 4 and 5 affidavit by the 4 and 5. This law, the rule, no, I just like to point out here.
No, Mr. Barua. As has been, raised by the respondent, the learned AG. This court would like to know firstly the status of your
License.
Yes. Now that license would be required. When is the latest, license that you've got, or renewal or whatever? Number 2, permission to construct in that particular area within the industrial estate. That is, I think that is there on record.
That is there. That's affidavit I did file.
Okay, so that is there. They are disputing that.
No, Milord, that is not there. Permission is not there on the record. I didn't see any permission, Milord.
Lordship, this blueprint which is submitted. What does it mean blueprint? How do you consider the blueprint, Your Lordship? No, this is the blueprint. This is the blueprint. Blueprint.
True.
We have submitted to the department. Department has countersigned. Countersign is allowed. So thereafter the construction started.
Can you see, Milord? Can you see the blueprint also,
Blueprint,
Milord?
yes.
My friend is trying to mislead this honorable court. I'm sorry to say.
Yes, that is the small that copy.
The Lordship will see additional 23rd August. This is only measurement of land, Milord.
And next page, Your Lordship, page 6. Page 6.
There is no permission. Where is the permission, Milord?
Page 6.
Page 6, yes. This entire drawing is there. How the structures would be.
No, this is the drawing.
Where-
See, Mr. Barua, this is the drawing. This is drawn by so and so. But where exactly is the noting that this drawing has been accepted?
No, this
There has to be a letter, Milord, a formal letter that your drawing has been approved and permitted, Milord.
Okay, Lordship, I'll try two things, bring it on record because I have to bring that license with I have to what things. Okay, I'll just communicate because this whole matter because documents are very quite long. I may give some time so that I can bring on record.
So we'll adjourn the hearing.
Milord, I was saying, Milord, at this belated stage, Milord,
Let
my
him
friend is trying to build a new case. Trying to build a new case.
No, Your Lordship,
I will.
as per the requirement of the court, I'm bringing on those records. It's not something new that we're bringing on.
The court will not require. It is for the petitioner to place the case, Milord.
let us satisfy the petitioner.
No
This is the very
problem.
old.
Let us humor him. You find all whatever necessary.
Yes, whatever things I have, I will file it.
But these should have been. You should have presented your case accordingly. No, in such a way that it becomes
Actually,
clear to the court.
I apologize for that, Your Lordship. Only the additional affidavit that I filed, no, to bring on the inception of the thing, because the inception you're talking, that means initially when it started. So I
But
filed.
that is the crux of the issue.
Yes, sir. I apologize for that. I'll just submit
Until
it.
and unless, as Mr. Kumar has said, until and unless you are firstly permitted to function, then you are given approval to erect or construct. Whatever the action of the respondent is concerned, that should not be, that should not come in your way, or it should not affect you.
So, Your Lordship, I understand. I understand the point that in that context, if I go to my petition and that annexure
Because
8,
you apply this.
so the latest communication is already proof that I'm just still holding the line. But still, I'll bring it on record, Your Lordship.
Then you can refer to that.
Bring on record.
Milord, we would like to respond to the whatever documents my friend is going to submit.
Do file it in the form of additional affidavit.
Okay,
And let them.
I'll
With
file,
liberty to the respondents to respond to the documents. if he-
I'll file 2 different affidavits so that bring on the things. Your Lordship. So maybe because I have to collect from Jayanti Ayers, so
2 weeks.
maybe 3 weeks, Your Lordship, kindly, because he'll search it, then he'll pass it to me.
2018 matter.
Yes. 2 weeks will be a little bit short time because I have to travel to because he's an aged man,
Ms. The Learned EG, Mr. A. Kumar, has advanced his argument on behalf of the respondents, all the respondents. All the respondents?
All the respondents, my lord.
Respondents. However, in course of hearing, this court has made a query on certain points to be clarified by the petitioner, particularly with regard to the extent of the initial license issued to the petitioner to function from the said industrial estate, and also with regard to the permission to erect or construct the sawmill therein. The Learned Counsel for the Mr. A. Varwa, Learned Counsel for the petitioner, has submitted that he may be allowed to file an additional document to bring these documents on record. Pray allowed that the additional affidavit be filed within the next date fixed with advance copy to the respondents to allow them to respond to the same if so desired. The whole exercise is to be completed within 3 weeks from today, this matter thereafter. So there will be no question of matter coming up after 3 weeks and then giving you more time to file your response. As soon as you
They should at least,
as soon as you get
they have to give us in advance, my lord. At least they have to give you at least 10 days in advance. We need at least 10 days to get documents from concerned department.
Once it's ready, I'll pass on to
yes,
them.
you'll do it.
So now, one thing I just want to confirm from, I think, whether this affidavit for the MECL, I need to submit to direct to the hand over to or go to the department, because
The lawyers, please submit it to the lawyers who are already on record.
This becomes very cumbersome.
But any new
No,
petitions, this is not a new petition.
once
This is a
Wakala
running
Kama is
case.
filed, my lord.
We are already on. We are already on
Yeah,
record.
so why
On
would your
record, there
department
should
issue
not be
such a direction?
I do not know why
because
my
I have
friend
the
is having
receipt
so much
copy also that I
difficulty.
submitted to the department.
You
Definitely I got the
you
information.
sort out that with your department.
From supplementary cause list, item number 1.
May it be your lordship, yeah?
Yes, Dr.
My lord, the petitioner is operating a coke plant with the permission, my lord, consent to establish and the consent to operate the coke plant, my lord. And in the year 2023, your lordship, page 43. Page 43, my lord.
Yes.
A closure notice was issued on 7th of December 2020.
Just a moment.
Your lordship, my lord.
43.
43, my lord.
Yes.
In reference to lordship, the order dated 7th of December 2020, that was closure notice was issued for not following some of the pollution norms.
Just a
and
minute.
after the
Okay.
my lord.
Fine. Please continue.
After the pollution norms were followed, my lord, you also see the order.
Yes.
With reference to the above, this is to inform you that in view of compliance to the board's direction, the closure notice for operating the coke plant located at so-and-so issued and against your unit so-and-so is hereby withdrawn with immediate effect.
Yes.
So the closure notice which was given, my lord, in 2020 was withdrawn in 2023, my lord, April 2023. Now, thereafter, your lordship, the consent to operate was up to 2023-24. That consent to operate was given at page 45, my lord. Establish and operate, my lord, after the withdrawal of the closure notice.
Yes.
And this was approved 23-24, my lord. After that, my lord,
This is the renewal of the CTE.
my lord, up to 24, 31/3/2024.
Okay.
Now we will also make any similar at page, my lord, 50. My lord, after that the petitioner applied for the renewal of the consent to operate, my lord,
Yes.
for 2024-25 as well 25-26. But when, my lord, in the meantime, my lord, there was a procedure to obtain the NOC from the Department of Mining and the Geology, my lord. Now, when the petitioner went to the office to inquire about the application of NOC, then the petitioner came to know that there was a notice issued which you also find at page 50.
50?
Page 50, my lord.
Yes.
This was a notice dated 10th of January 2024 about some demand of rupees 1 crore 22 lakh something at page 51, my lord.
Yes.
Now, this notice was sent as a wrong address at page 52, your lordship may see, and it was received by us on 6th of March 2024 at page 52. We gave a letter
Page
that the
52.
notice was sent 52 that the notice was sent at a wrong address, and thereby the copy was the same was given on 6th of March 2024 only, below.
Where did you see that?
No, in the first paragraph, first page, the above letter was addressed to so and so with so and so address, whereas the plant is situated as so and so, and due to which we have not received the letter. However, in our regular visit to the mining department, we have received a copy only yesterday only, and we could not reply to a letter as advised.
Okay. Yes.
Now you will see me thereafter see the page, next page, page 53.
Yes.
This we addressed a letter to the Meghalaya State Pollution Control Board for renewal of the license for 2024-25.
Yes.
And the next page, you will see at page 56, we applied for 25-26.
Yes.
Then you will see at page 57, we addressed a letter to Honorable Mr. BP Katki, who was the chairman of the board, that there was a mistake in the calculation of the demand which was given to us, and the letter was submitted to the chairman for re-evaluation of the demand. Now, thereafter, you also see page 59, the Meghalaya State Pollution Control Board, by giving reference to the order dated 2020, you also see the reference 2020.
Yes.
We said with reference to the above, it is informed you that the board has issued the closure notice for so-and-so under reference, and in this regard, you have a directive to ensure that so-and-so is stopped in operation with immediate effect. Now, we lost it in 2020, that was withdrawn. At front, we lost it in 2023, it was withdrawn on fulfillment. That was page 43. You lost it, page 43 once again. The reference is of 7th of December, closure notice,
Yes.
And at page 59 also, you'll also see this was the same reference which has been given.
Yes.
Whereas this 7th of December 2020 was withdrawn, while order dated 22nd April 2023 as page 43.
Yes.
Now, without taking cognizance of the fact that the earlier closure notice was withdrawn by the earlier order, the order was passed that the unit was directed to be closed, so it may be closed. Now, thereafter, you also can see, the next page, page 50,
Yes.
This was a letter again written for re-evaluation of the demand. That was in 2024. We wrote a letter. Now, in reply to that, we received a letter at page 63.
In page 60, what have you asked for?
Page 63 is the letter, Page 63. 60, we gave a letter, that to re-evaluate the demand.
Okay.
And
because
and
you say
63,
that because you say the calculation is wrong.
My lord. And 63, we received reply, So with reference to the subject cited above, I am directed to inform you that in view of the upcoming Lok Sabha election, some coal auditing members have been drafted for election drafted for the election duty. Hence, your petition will be taken up after 19th of April 2024.
Yes.
Now, on 20th April, we will be contacted. He said that after the election duty, the officers have not come back, so they will come. It will take 2 weeks more. Now, in the meantime, your Lordship may see page 64.
Yes.
This was a letter addressed by the Deputy Commissioner to the General Manager. Says, my Lord,
yes.
with reference to the subject above, I forwarding her with a letter number so-and-so received from the Chairman, Meghalaya State Pollution Control Board, Shillong, which is self-explanatory. In this regard, you are directed to comply with the order and submit that is the closure notice, my Lord, by which you are directed that you take the action on the basis of the 20 order, the order of earlier order, my Lord.
Yes.
So the Deputy Commissioner said that for compliance. Now we'll also see the next page, page 65.
See, what is this letter dated 27th March?
27th March, Lord. 27th March, page number.
It has been referred to in your page 64.
Page 59.
Well, 27th March is page 59, Lord. That is the order by which the closure was directed to be done.
Just a minute. Okay.
On the basis of the earlier order, 2020 order.
Oh, yes.
Now, you'll also kindly see, we again in Melody at page 66 inform the Deputy Commissioner that the earlier order of 2020 was withdrawn in 2023.
Yes.
Now, on receipt of this letter, my Lord, the Deputy Commissioner wrote to the Chairman, Pollution Control Board at page 67.
Yes.
Forwarding the letter received by from the petitioner, and he sought for the clarification to the undersigned in the above stated matter for further action in this end. So, my Lord, the Deputy Commissioner forwarded the letter received from the petitioner that the said order was withdrawn in 2023. So he may not sought for a clarification from the Pollution Control Board.
Yes.
Now we have page number 69 your OCMC. The petitioner requested the State Pollution Control Board, your OCMC. Yes. I would like to request you to letter to verify regarding our CHU renewal, which was email on so-and-so. We would request you to extend the validity of the so-and-so till such time the further renewal is pending, because the mining and geology department said that we cannot evaluate now because of the Lok Sabha election, and thereby till the evaluation is done and the demand is calculated, NOC cannot be given. So till the NOC is given, the renewal will not be there, and that is what it has been said, at page 70. The Pollution Control Board is writing,
Yes.
With reference to the above, it is to inform you that the application for renewal of the consent to operate so-and-so and under the ID number so-and-so cannot be processed till you submit the NOC from the Secretary of the Government of Meghalaya Mining and Geology Department, declaring that there is no discrepancies detected in the coke plant link of the Kali so-and-so. Now, my position here, Lordship Meghalaya, first of all, the closure notice was based on a order passed in 2020, which was withdrawn by the Pollution Control Board itself in 2023. So that closure notice is absolutely illegal. Secondly, my Lord, I have applied for the NOC in the Mining and Geology Department, and the evaluation was directed to be done by the committee of the headed by District Attorney, and the evaluation could not be done because they have said that our officers are busy in the election duty. Now, because of the officers are busy in the election duty, the evaluation cannot be done, and without the evaluation, the demand cannot be determined and NOC cannot be issued. Now, the Pollution Control Board says that till you issue give the NOC, your consent to renew will not be done. So my prayer before you is that, first of all, the closure notice which was issued is absolutely illegal, because that is on the wrong facts itself, because that is based on the 2020 order, and 2020 order was withdrawn in 2023. Secondly, my Lord, till the evaluation is done, evaluation I have not stopped. The geology department is saying that the evaluation cannot be done because our officers are busy in the election duty. So the evaluation has to be done, and then only, my Lord, the NOC will be issued. Now, till the evaluation is done, my Lord, if any steps are taken, then I am nowhere, my Lord. My prayer before Lordship is that, my Lord, first of all, the closure notice which is there, which is illegal, a prima facie illegal, my Lord, that may be stayed, and thereby the Mining and Geology Department may be directed to evaluate the demand, whatever demand is there on the basis of letter, within a given time frame of Milord, because if the evaluation is done, assuming that demand is found to be nil, the NOC will be issued immediately. Assuming 20 lakhs demand is found, the 20 lakhs will be paid and the evaluation and the NOC will be issued. But till the evaluation is done, Milord, how I can press them to issue make the evaluation. They have said that their officers are busy in the election duty. So my query is that a direction may be issued to mining and jewelry department to make the evaluation within a particular period, like 2 weeks, 1 week, whatever you will also be think fit. And till that evaluation is done, the step for any further step for closure of the unit should not be taken.
Yes. Yes, Mr.
Minute, please, Your Lordship.
Yes.
Lordship, kindly see the prayer first, my Lord. Page 31, my Lord.
Yes.
Prayer is, my Lord, that in the premise, it is therefore most respectfully prayed. Calls for records, stepping aside and questioning letter of 27th March 2024 issued by Meghalaya State Pollution Control Board addressed to the Deputy Commissioner and the Deputy Commissioner to ensure that petitioner company stops this production with immediate effect, and also why writ in nature of mandamus or any other writ or like nature or order of direction should not be issued directing the respondent Meghalaya State Control Board to make provisional renewal of consent to operate until NOC from Mining and Geology Department received as to why written. So the prayer, my Lord, is direct the Meghalaya State Pollution Control Board to give provisional renewal, my Lord. That is the final prayer which is being sought, my Lord. And interim prayer is also today that direct the Meghalaya State Pollution Control Board to grant interim renewal, my Lord. Kindly see the renewal document, my Lord. Page 45.
Yes.
Consent to operate under Section 25 and 26 of Water Prevention and Control Pollution Act as amended in Section 21 of Air Act Pollution Act as amended for operating lamp coke manufacturing unit with located at so and so place is hereby renewed under the following terms and conditions. And 2, my Lord, the consent to operate is valid for 31st March unless otherwise suspended or revoked. The consent may be modified in the whole during the violation of etc. My Lord, so the consent itself was valid till 31st March 2024. My Lord.
Yes.
And the beyond that there is no consent, my Lord. Beyond this 31st March 2024. What is a prayer before your Lordship is to extend the consent under which are statutory in nature, my Lord. The ground which is being taken, my Lord, is to direct the Deputy Commissioner to allow them to run the coke oven plant without proper consent, my Lord. Because there is some delay on the part of DMR to give NOC, my Lord. Now all these letters, my Lord, your Lordship will have kindly, this is all prior to March 2024, my Lord, 31st March. There is a process for applying for renewal, my Lord. Now, they are approaching before your Lordship on 30th April, after 1 month of the consent is over, my Lord. Therefore, at this stage, in my humble submission, there is no urgency, my Lord. Consent, your Lordship has seen, it is up to 31st March 2024. Beyond that, they could not have operated because there is no consent, and your Lordship is seen with the matter of coke oven plant. Even Honorable Supreme Court in series of cases where, my Lord, the matter is pending before the Honorable Supreme Court with regard to illegal operation of coke oven plant. I put a question to myself: how did they operate the coke oven plant after 31st March 2024? My Lord, when the consent was valid till 2024 only.
Was there? I think somewhere Mr. Dr. Saraf has indicated that the application for renewal has been made.
Yes, my
application for renewal has been made, my lord, but the application for renewal, Mr. Sir, because I've just got the copy in 10 minutes back, but still I will assist your lord.
Application for renewal.
This is at page 53, your lordship will see, 53.
Application for renewal post 31st March.
Yes, my lord, that is at page 53. Kindly see page 53.
No, before 31st March, my lord.
Yes, it is before 31st. I will be fair, my lord, in this case.
8th of March.
With reference to the subject cited above, renewal for consent of operator dated so and so. So this is
the
8th March. This is the 8th March later, my lord, 2024, my lord. But this was, my lord, as on today, the position is that after 31st March to 2024, they did not have the license.
Exactly. See, Mr. Kumar, based on this letter at page 53, what has been 53? 53.
53, yes, your lord.
So based on this letter at page 53,
yes,
the process is set in motion.
Yes, my lord.
So now what happened is the department, because of, as has been stated,
now,
because of the official being involved in
also, because
whatever. Hear me out. Hear me out. If I have understood, if I have understood correctly, otherwise
yes,
I'm at your mercy.
No, I'm sorry.
To twist and turn.
Very sorry, my lord.
See, as far as I could understand.
Yes, my lord.
Based on this application at page 53, because of the election duty by the official, the evaluation could not be done, for which the consent for renewal could not be issued. NOC.
Yes, my lord.
The NOC could not be issued.
Yes.
Now, without the NOC, the Pollution Control Board cannot issue the NOC.
Yes, my
So
lord.
that is the situation.
Yes, my lord. Your lordship is right, my lord.
So,
your lordship has correctly followed what the argument of my learned senior advocate, my lord. And I have also understood what is the case of the petitioner, my lord.
So what we can do is Mr. Kumar, is this.
Yes,
let the process follow. This court,
yes, my lord.
Either you or this court or anybody else cannot say at this point of time whether such NOC will be issued or not.
Yes, my lord. Yes,
and based on such issuance or non-issuance of NOC, whether renewal can be granted or not. So we are not on
yes,
that. We are not on that.
Yes,
as it is,
I fully agree.
As it is, as of now, this court will allow the process of evaluation to be carried out.
Yes, and in time bound.
And in the meantime, no coercive action to be taken against the.
But only question is, my lord, coercive action is, my lord, they do not have permission beyond 31st March, my lord.
Exactly. Why they did not have? Because of the process.
Because without permission, whether they can run the coke mill, my lord.
We are not saying we cannot say they'll run or not. The only thing is that we are saying that their plant should not be closed until the process is complete.
That is what I have no issue, my lord. I agree, my lord, because they can't run the plant beyond 31st March.
They cannot run. So we'll
that I have no issue,
my lord. My lord, just if your lordship permit me, my lord, after I applied for the renewal, this letter at page 59 has been issued on 27th March. Foreclosure.
Whatever the case may be, Doctor. That issue will be taken care of by the department. Even the letter will be taken into consideration when the evaluation process takes place.
I have no objection at all. I fairly, my lord, in the very beginning submitted, my lord, that your lordship may direct the evaluation to be completed within the, my lord, particular time. My lord, the particular time or within that, my lord, it may be taken up.
We cannot see.
But
the only thing.
But my lord,
please.
My lord, my submission was that, my lord, subject to your lordship consideration, my lord, that evaluation, I have no problem at all, my lord. If evaluation, they say that no NOC will not be issued, naturally, my lord, the renewal will not be there and the plant will be closed. There is no doubt about it, my lord. If the NOC is not issued, the renewal of the consent will not be there and it will be closed. But, my lord, I am submitting before lordship, this is not a case of normal court cases which are running illegally. This is not running illegally, everything.
That is not the issue here. Let's not go into that.
My lord. So my submission is that, my lord, till the evaluation is, my lord, done, the evaluation within 15 days, your lordship may do it. 7 days if they can complete it. I have no, my lord, objection at all. If they can do it within 7 days, I have no objection at all. But till the evaluation is done, because this is not in my hand, my lord, I am not the defaulter. So, my lord, that until then, my lord, the closure, the coercive measures means to close down. Now, my lord, if it is closed down for 7 days or 10 days, within which they can do it, my prayer will be there, my lord, before I lordship, that no coercive steps should be taken.
That's all.
My lord.
My lord, they cannot run. The only thing your lordship may clarify that they cannot run beyond, and if they have been running beyond 31st March, it is illegal, my lord.
My lord, if on the one hand, my lord, the state
in that case, Mr. Kumar, this court will
Yes,
direct that if you say that they cannot run, fine. The only
Yes,
thing is
ma'am.
that the court will direct the concerned authority to complete the evaluation within 1 week.
Because, my lord, I have whatever direction your lordship, we are bound to follow the direction, my lord.
do it
But
within-
kindly see, but kindly see, my submission is, my lord, my submission is, my lord, there is these are the statutory permissions.
Yes, yes.
Permissions have been granted till certain date, my lord. Now, if I do not have permission as a law-abiding company, my lord, if I do not have permission beyond, can I run the plant beyond that, my lord? For whatever reason, permission has not been
It has not been
granted.
rejected, my lord. It
That
has
is
been
not the point.
rejected.
You are forgetting the circumstances which surrounds
My lord,
such
my
a
lord,
issue.
if I place the circumstances also, my case is that they cannot run after 31st March. My lord, your lordship record, and if they are running, it is a completely illegal against the Supreme Court judgment in this case. Supreme Court directions are there in this case, my lord, in all cocoa plant. If you do not have permission, how can you run the plant, my lord? I put a question to myself.
I will submit, my lord.
We can't run it, my lord. Your lordship may give time-bound direction to the state. Why this has not happened? Because I have to place my counter. Give me time, my lord. Till 3 days, I will file counter, my lord. And then thereafter, your lordship will consider this aspect also, whether who is at fault. Because this is the version which I have got in 10 minutes back. They were having ample time. They could have. This is the ambush tactics.
Mr.
I will
Kumar,
say this is the ambush
Mr. Kumar,
tactics. They could have given today only. They have filed, gave me copy right now. I don't have instruction. What they are saying is correct or not, my lord. But still, I am conceding
So
that
fine.
Be,
If that is the case, if you wish to argue the matter in its entirety,
yes, my lord, I want to place my counter.
Within 3 days, we do that.
Yes, my lord, please do that.
So the matter will be heard in 3 days' time, Dr. Saraf.
But look, 3 days they will not take the coercive measures because
Yes,
tomorrow
3 days. Okay, fine. 3 days
My
and 3 days. This court will allow.
The only thing is, my lord, coercive measure does not mean operation of illegal coke oven plant.
No, closure notice is only, my lord.
Let their statement be recorded that they are not running it. I have no difficulty.
My lord,
They are not making the statement, my lord.
My lord, just a minute, my lord, can you see those cases which my friend AG is
because they cannot run after 31st March. Where is the permission, my lord?
My lord, they were running without the consent to operate all those issues in the beginning. I have applied for the consent to operate in time. Now the consent to operate in time has not been issued only because of their fault. Now it cannot, and the closure notice which was issued on 29/7 March, my lord, that is illegal. Let it be stayed. That 29th March order is on the basis of the order of the 20th, which has been withdrawn. So if that is the order, that is actually illegal. And if that order is illegal, then closure notice has to be stayed.
My lord, permission, I have shown at page 53 once again, permission was up to 31st March only, my lord.
I am not disputing.
And after that, if the proposal has not been considered for whatever reason, they should have come immediately after 31st March. They cannot run after 31st March, my lord.
But how I can come, my lord?
They are coming on 30th April after 1 month, and they are saying that I am entitled to run the coke oven plant without consent to operate, my lord.
But can you see the correspondence?
We will not take coercive measure, but they can't run the plant without permission, my lord.
Then what will coercive measures mean, my lord?
My lord, can they run the plant without let their statement be recorded? We are running the plant without consent to operate.
My lord, if without the fault of the petitioner, my lord.
My lord, it's a question of permission.
Let the London AG make the
permission, my lord. Clearly, my lord, page 45, kindly see clause. The consent to operate is valid for 31st March 2024 unless otherwise.
That is noted. That is noted.
So beyond 31st March, if I have not got the permission for whatever fault, whosoever fault, my lord, can I run the plant? Can I run the license? I don't have motor vehicle license. And I will say that look, I have applied and it is a fault of state government. Still, I am entitled to run the drive the vehicle. it's like saying same thing, my lord. We will not demolish, we will not do anything, but they can't run the plant beyond 31st March.
Since you have committed to file the affidavit within 3 days.
Within three days, my lord.
So you file, and on the third day, matter will be heard.
Yes.
Matter will be heard finally.
Yes. 3 days, my lord, because by Friday,
yes.
Today is Monday, we will file by Thursday, my lord. Friday, your lordship may have it.
So we'll do that.
But they can't run the plant. If they are running the plant, they are acting illegally, my lord.
Fine.
Because law is law.
Fine.
Well, one sentence, if your lordship permit me. Only one sentence.
You have waited for so long. You might as well wait for another few days.
No, I'm only one sentence, my lord. If your lordship permit me, my lord, only. I will not, my lord, without your permission, your lordship, I will never do it, my lord. My lord, my submission is that, my lord, there must be a notice for closure. Now, closure notice was issued on 29th March on the basis of the letter dated 20th of order, which has been withdrawn. My lord, at least in the meantime, the notice order dated at page 59 should be stayed, because prima facie that order is illegal.
Dr. Sarar,
my lord,
the fact that the closure notice has been issued or not issued is immaterial at this point in time. What is required now is to confirm your renewal. Whether there's a closure notice or not. If your plant is not renewed, then no NOC is given, then it's pointless. It's pointless.
Absolutely, I'm agreeing with you. If the NOC is not issued, renewal is not there.
Let us focus and concentrate first on the issue of renewal and NOC.
Well, either your lordship may say the status quo today, or your lordship may say no coercive measures may be taken.
Then status quo will be issued.
My lord.
Status quo, they should not be running the plant, my lord. If they are running the plant,
how
they
the
can't
positive order in my opposition, my lord.
My statement may be recorded. We will not demolish it, my lord.
Yes,
that is the good enough, because they can't run the plant.
Okay, fine.
We will not demolish the plant as per the order of the court or the Honorable Supreme Court, my lord.
Dr. Ashok Saraf, Learned Senior Counsel, appearing for the petitioner. It is the submission of the Learned Senior Counsel that the petitioner company is running a factory at Muklep, Ladrambai, in the East Jaintia Hills district of Meghalaya, on the basis of the consent to establish and the consent to operate in compliance with due provisions of law.
The last consent to operate is at page 45, my lord.
It is also submitted that the last consent to establish was that is 31st March.
That is 24th April 2023. Up to 31st March.
Yes.
Up to 31st.
No, we'll just take on the consent to operate.
My lord.
Last consent to operate is valid up to 31st March 2024.
My lord.
Thereafter, the petitioner company, following due process, has filed an application on 8/3/2024 for renewal of the consent to operate for the period from 1/4/2024 to 31/3/2025. the said application was duly processed with the department concerned. However, for renewal of the said consent to operate, a no objection certificate under bracket NOC is required from the Department of, that is the Pollution Control Board.
Mining and Geology.
From the Mining and Geology Department, Government of Meghalaya. It is clarified that until the NOC is issued, giving a no objection to the company, to the petitioner company, the renewal of the CTO cannot be issued. It is also the submission of the learned senior counsel that the petitioner company was in receipt of communication to the extent that the process for the renewal could not be completed in time due to the occupation of the concerned officials with the ensuing general election. This being the case, till date, the said NOC could not be obtained nor the renewal affected. In such a situation, the Learned Senior Counsel has submitted that this court may be pleased to direct the concerned department, public officials to process to expeditiously take up the process of renewal, and in the meantime that no coercive step should be taken against the petitioner company till the said process is completed. Next, per contra, Mr. A. Kumar, Learned AG, though not controverting the factual situation as has been pointed out.
My lord, I do not have instruction, my lord. As on today, I cannot say because I have no instruction, my lord, whether what is being said, because I see these letters.
I'm not
my
saying,
lord, so therefore,
I'm not saying your instruction. I'm saying that you are submitting. It's
my
your
lord,
submission.
And what I'm submitting is, my lord, that
the facts of the case.
Because see, whatever is being said, my lord, because what I see that GST portal is there, because Justice Pataki is investigating the matter. I've read all those annexes now. My lord, there are certain grey areas in the facts also.
All the ancillary issues will be taken up when the matter is finally heard.
Yeah. Gray areas, because if I do say that I'm not controverting, my lord, then I will be accepting what my friend is saying, my lord, the London Senior Counsel is saying.
Fine.
So that I'm so I have to say this much that I need time to file reply within 3 days. Your lordship may consider this.
I'll rephrase it. Kundung Tungong, per contra. Per contra, the Learned AG, Mr. A. Kumar, has submitted that because of lack of instruction at this point of time, the state respondent may be allowed to file a detailed counter affidavit.
A short affidavit, my lord, because detail will require short affidavit on all the short affidavit.
To file a short affidavit in this regard, and the matter to be finally heard on the said affidavit being filed. It is, however, I'll not put that on record. This being the case, without going to the merits of this petition at this point of time, suffice it to say that it is the considered opinion of this court that pending final decision as far as the said renewal is concerned, as well as the issuance of the NOC, and also pending final hearing of this petition. No coercive action should be taken against the petitioner company.
Hello. Yes, my lord.
I think that's
yes.
about it.
Only thing is that it is your lordship may clarify that they cannot run the plant after 31st March. If they are running, then my lord, they are.
However,
my lord, I have a great objection to it, my lord. In my petition, my learned friend is saying that
if they are running, my lord, then I have to take coercive action. Under which
my lord, the coercive action
they are running the plant, my lord, after 31st March. I put a question to Mr.
If the application is pending, my lord, and the other
and your lordship kindly see their page 76, 178, what they say.
See, Mr. Kumar, 3 days time is allowed to you, to both the parties.
But my lord, I have no issue. The only problem which I have, my lord, they can run as many days as possible.
Okay.
I have no issue on that. I am only on fundamental issue.
Yes.
If they are running it without permission, it is per se illegal, my lord. And that is and your lordship will not any such act. That's what therefore, however, your lordship may say that they know, because if they are running after 31st March,
they cannot.
It is a ground to close down everything, my lord.
That's true.
It is a ground for therefore they should not run what they are going to what they will be doing, my lord, in the garb of coercive or they will be running the plant, my lord.
The point is taken, Mr. Kumar. Dr. Sarah,
Yes, my lord.
you are also restrained from operating your
plant. On my petition,
in case you succeed, as far as your renewal and NOC is concerned, then you have a case for damages.
In my petition,
you have a case for damages.
But I have one submission. In my petition, getting an advance order against me without any order from the department that you don't operate, my lord.
We are not on that. We are not on the. Again, I'm reiterating. We are not on the issue of closure. We are only on the issue. We are only on the issue of the validity of your license.
For 3 days, your lordship may only object that no coercive measures may be taken. Inviting an advance order.
The issue is that if they should also record. They should make the statement that they are not running the plant, my lord. I have no issue. Because they are not making the statement and no coercive measure, my lord, they will be running the plant illegally after, and they have been running it after 31st March. If I replace the evidence,
time is taken by
they may not run in the light of your lordship's order. They should not run the plant. Because if they are running the plant, I can't take action, my lord. They are not even making the statement that we are not running the plant. They do not have permission, my lord. They do not have permission and they are running the plant and they are seeking no coercive action, my lord. This is abuse of process of law.
My lord, learned AG will take time for instructions, for taking instructions, and on the other hand, he will also invite an order that no issue will be operated. My lord, either
because permission is up to, as per their own record, is the permission is up to kindly see page 76, my lord. What is the 28, my lord?
Fine.
Where I disputed.
That I think I'm agreeable with Mr. Kumar. I think as far as the law is concerned, since there is no license to operate, you cannot do it.
Yes, my lord. That is what I want, my lord. I have nothing against anyone, my lord. Only on this issue.
The only thing is
on this law.
The only thing is, Mr. Kumar, you have to ensure that within 3 days' time.
Yes, ma'am. We will do that. We will do that, my lord, because we have to get the instruction on the matter. Whatever status report, anything, we will place it before your lordship. But the legal position is very clear, my lord, very unequivocal, that nobody can run the plant without permission, my lord. And what they are seeking is no coercive action in the light.
Petitions company. It is also, however, made clear that the company is not to operate without valid license in the
Grateful.
interim.
For 3 days, otherwise
just one.
My lord.
As has been submitted by the learned AG, the affidavit, counter affidavit is to be filed within 3 days from today, with advance copy to the petitioner to file the rejoinder if so desired, and the matter to be finally heard on the next date fix.
No, Lordship object that they will not operate till the next date. Otherwise, they will go on taking time.
Yes, that is why. That is why. See, that is why. It is an assurance given by the AG. He is the.
I know, my lord.
He is the senior most legal officer of the state.
No. He's very fair also. But from my side also, my submission that
whatever the case may, if worse comes to worse, you file a recording of this hearing. So we'll fix the matter on first then, on Friday. Friday is what date? Third.
Friday or Monday may not because I can give the copy to my Friday and Monday. They can file it.
You say 3 days. 3 days means, in fact, it should have been Wednesday.
No problem.
But even then,
no problem.
Friday is
yes,
good.
Yes,
Thursday they can send by mail also. There is no problem.
As agreed to
WhatsApp is there.
As agreed to by the parties, list this matter for final hearing on
Third. My lord.
Grateful, my lord. My lord, may I mention one matter, my lord, of great urgency, my lord. What has happened, my lord, that a case has been filed, a case of rape accused, my lord. 3 accused were there in that case, my lord. And one of the accused has been granted bail by the district court, London District Judge District Court, on the ground that on the date of offence he was minor. He was about 18 years of age, my lord. October to 2023 in Nongthamai this incident happened, my lord. And after that, this gang rape, my lord, the video was circulated in April 2024, my lord, when the person was major, my lord. The person was granted ad interim bail, and investigation has come to a grinding halt, and we have moved the application, my lord. Your lordship may take up the application tomorrow, my lord, for a stay of the order. Stay of the order.
To come for cancellation of bail.
Cancellation of bail. Cancel because right now ad interim bail has been granted by trial court, and the FIR is registered on 24th April only, and the video has been circulated by the accused, my lord, of the offending.
You should have approached the trial court itself, the court which has passed the order.
The trial court, my lord, trial court granted interim bail after hearing so only this court can stay the order, my lord.
No, even under 439, the court 439(2), the trial court can take up the matter.
And there is a question of jurisdiction, lack of jurisdiction.
So,
I think there is a lack of jurisdiction also.
I think, Mr. Kumar, immediately you go and approach the trial court. If any,
I will place. Let me place my bail cancellation order. Your lordship I will place because it's a juvenile justice board which is a competent authority.
Fine.
So it's a case of lack of jurisdiction also. It's a case of lack of jurisdiction also. I will place the material. Your lordship may take up this matter tomorrow.
Fine.